HarperCollins, it's been a real honor to publish this book. At a time when conversations around law, citizenship, justice, and democracy feel more urgent than ever, this book is a stark reminder that the Constitution is not self executing, it depends on people who are willing to keep asking what justice means and whom it is meant for. Now I have the honor of introducing our distinguished guests who will be speaking today. Indira Jaising is a pioneering lawyer and human rights activist known for her work on gender justice, labor rights, and constitutional freedoms in India. A senior advocate at the Supreme Court, she became the first woman to serve as Additional Solicitor General of the country. She also served as a member of the United Nations Committee on the Elimination of Discrimination Against Women and was instrumental in drafting the Protection of Women from Domestic Violence Act 2005. She's a co-founder of the Lawyers Collective, an organization that has played a major role in advancing public interest litigation and rights-based advocacy in India, and a co-founder of the Leaflet, an independent digital platform for critical analysis of legal issues. She was awarded the Padma Shri in 2005. In conversation with her, we're delighted to have senior journalist Sreenivasan Jain, who will be in conversation with her. Sreenivasan Jain is an award-winning broadcaster and journalist. He's currently freelancing with Al Jazeera and News Laundry, producing hard-hitting and insightful news documentaries and major international series featuring interviews with world leaders. For close to 3 decades, he was with New Delhi Television, India's leading 24-hour news and current affairs broadcaster. When he left NDTV in 2023, he was the network's group editor. He's a co-author of Love, Jihad and Other Fictions, a book that debunks the conspiracy theories of India's Hindu supremacists. He's a recipient of several major national and international awards, including Journalist of the Year at the Ramnath Goenka Awards, the Red Ink Awards, the World Silver Medal at the New York Festivals, the ENB Awards, and the News Television Awards. Can I please invite both of you on stage? Over to you both.
HarperCollins, Indira Jaising, thank you very much indeed for giving me this chance to have this conversation with you. I read the book. I was very happy to see that you're as forthright in the book as you are otherwise, which is always good news for a conversation, for an interviewer. It's a full house, as we can see, a reflection of your extraordinary career and the sort of goodwill you have in the legal fraternity and beyond. I also believe the Chief Justice was expected today. Is he able to make it? Are we to wait for him, or should we carry on? Now your mic is here.
Yeah, I think we should proceed. He did say to me that he has been called out by the Prime Minister in relation to the BRICS Judicial Forum meeting. So we should in any way proceed. Where's the need to wait?
Okay, fine. All right. We'll carry on then. There's a lot to get into, and time is short. So let me start with what I understand is the heart of your book and central to your work, which is the Constitution and constitutional principles. So let me start with a broad brush question. Do you believe, and this is, by the way, the subject, as you know, of the Constitution, of a very active debate in this country currently, so it's quite timely. Do you believe that the legal system has been effective in acting as a guardian of the Constitution and protecting constitutional principles in the 6 decades or so you've been practicing? Or has it, as your book suggests, somewhat fallen short?
Well, to begin with, I would like to draw attention to the title of my book because the Constitution is very personal to me. I'd like to say that loud and clear. And I guess part of the reason is because I have nowhere to go, no one to identify with. Being a migrant, a refugee from Pakistan, And the question has always been in my mind that where do I belong? And in this country, no matter where you go, no matter who you meet, they will ask you this first question: where are you from?
Right.
And after a long sort of introspection, I found the answer. And I said to myself, I belong to the Constitution of India. I belong there. And if you ask me that, because there is no state in India known as Sindh. Okay, so what answer can I give?
Right.
So I
So
said,
hence constitution is your home.
it is indeed.
Okay.
And it is not, it's what kind of home is it? It's the values of the Constitution which I identify with and which makes me identify with my co-citizens, my fellow citizens.
Right.
It's my bond with my fellow travelers.
Right. That's an important point, that it's personal to you. But coming to my question
Yeah.
about the legal system, the judiciary,
Yeah.
has they been effective in safeguarding constitutional principles, or
Okay.
is there much there to be desired?
Okay, so first and foremost, if you've read the book, you'll know that all governments, regardless of which party they belong to, have tried to kind of shake the foundations of the Constitution. They have. And obviously, the first time we saw it is when the emergency was declared. And the consequences of it we all know.
Yes.
But currently also I believe that yes, the Constitution is under threat. It might interest you to know, some of my colleagues are here, those who recently argued the Sabrimala case with me, but it might interest you to know that the word Hindu appears in the Constitution of India only once, just once, and not in the preamble. It is in the text of
Okay,
the
that's
guarantee.
interesting. I have to confess, I didn't know that. Only once in the entire book.
Only once. And that is in the context of the guarantee of the right to freedom of religion. Okay. But in a very, very progressive context, it appears, it says Hindu places of worship can be thrown open to all classes and sections of people.
Right.
Now, it is not my mandate here to talk about the Sabrimala case because it's sub judice. There is one little.
So I don't want to interrupt, but I see where you're getting at. You're talking about the fact that the word appears only once in the context of what you're saying, that there is a certain threat to the Constitution. There's a sense that we're drifting towards majoritarianism. And I want to come back to that in a second. But if I can just take you back to the arc of your journey, in a way, which you outline in the book. You say that when you started your career in the 70s, even then you noticed, and I'm quoting, deference amongst judges to executive authority, something which resonates very much today, but you noticed it even then. And yet, in that time, you talk about how you were able to secure rights for marginal communities like pavement dwellers and street vendors, despite that deference.
Yes. So the answer to the first question about deference, it's almost like observing which way does the sun rise. It's like, it's an observation. It's nothing more than an empirical observation. But you see that with successive chief justices, regardless of the party in power. Okay, so let's be very clear. This really doesn't have much to do with who's in power, but it's like turning towards the rising sun.
Right.
And so, yes, I would say there is this deference. But then the question arises, how does one... First of all, I took a decision long back that is not a good enough reason to abandon constitutional courts.
Right.
If we, those of us who believe in democracy, if we abandon constitutional courts, then it's all over for us. So this is the reason why, despite everything, I chose to continue with my practice in constitutional courts.
Yes, in fact, you're right, saying that it's important to use the courts not just as a shield, but as a sword. It's not just to defend rights, but to expand them.
Yeah.
And to that point I made, that when it came to street vendors, when it came to informal sector, and so on, homeless people, you were able to, along with a team of public-spirited lawyers, win some fairly significant judgments, landmark judgments.
Yes, indeed. This is an observation there in the book that in the 50s, in the 60s, most liberals, left-wingers did not use the courts for their potential to bring about social and economic change.
Right.
Most battles revolved around the whole zamindari issue, the abolition of zamindari, land reforms, etc. But very little about working people, very little about homelessness, very little about self-employed. It's only in the 70s, 80s that people started using the court as what I call like not just a shield but also a sword, where you are proactively asking for the implementation of your social and economic rights.
Yeah.
Until then, it was civil liberty, it was civil rights. You know, people who were in detention, A.K. Gopalan, etc., they went to court to get themselves out naturally. But they did not see the court as an instrument where you can achieve social change. And that's where people like me made a difference. We
Right.
decided that the court belongs to us.
And also, when it came to the question of gender discrimination, which is another area where you worked extensively on, how would you assess the track record of the courts there, especially when it came to instances where gender rights clashed with religious beliefs or so-called cultural norms, like the Sabrimala case? How would you assess the judicial response to that?
As I said, Sabrimala is sub judice. I will not talk about
course,
it.
but broadly.
But broadly. I have often written this, and I stand by it, that the women, when it comes to the issue of violence, they are more honored by our courts in their death. You will find, long lectures when you have a dowry death. But when she's alive and she's going to court and she's saying, protect me, then you might hear arguments like, oh, you're misusing the law. Okay, so this is a strange phenomenon that we really seem to be very concerned about a woman after she's dead, but not in her lifetime. I find it very painful and have tried to resist it all along. So on the question of gender justice, the record is very mixed. On the other hand, you do have judgments like Vishaka, which have declared the right to be free from sexual harassment as a fundamental right, as part of the right to work. So you have this very strange contradiction where if the law is kind of sanitized of all reality, then it's fine. But the minute you get into a real flesh and blood person who comes before you, then all your stereotypes come into the picture.
But even with Sabrimala, with the 2018 judgment, that was a progressive judgment where the court, the majority bench, ruled in favor of allowing women access to the temple.
In my opinion, it's a no-brainer whether women should be allowed to enter temples. It's just a no-brainer. So you're right, the judgment was progressive, but obviously you and I were wrong because it's a subject matter of deep debate.
Currently.
Yes, whether women should be allowed to enter a temple or not. I had to say in the courtroom, I said, I just either show me one text which says women can't enter temples, or you tell me that women are not welcome in the house of God.
You were talking about how the initial phase was about battling for economic rights, social rights. There was a sense almost that political rights were taken for granted, and then you have the jolt of the emergency, and the judiciary's somewhat conflicted response to that. So perhaps that was the first wake-up call. But you also write about how today we're witnessing what you call a second transformation towards a majoritarian state. And you say quite candidly that it's the ruling party, the BJP, which is transforming the nature of the state from a liberal and secular republic into a Hindu nationalist one without amending the constitution. Is that more concerning in some ways?
Yes, it has always fascinated me, as it has fascinated many other scholars of the Indian constitution and Indian political science in this country, as to how we have managed to achieve, how this country has become so different, notwithstanding the fact that the constitution has not been amended. And this is where I do wish to make a difference between what happened during the emergency and what's happening now. During the emergency, it was the constitution itself that was used to oppress the general public. They used it. They invoked the emergency provisions, okay? So it's much more easy to fight a written text, a written document, to challenge it. What's happening now is, without changing the written text, every other form of transformation is happening. okay, without the change in the written text, and which is why it is so much more difficult to deal with. And therefore, I don't believe that we can just characterize it as an undeclared emergency. An emergency, for God's sake, is an emergency, okay? What's an emergency? It's temporary. We've gone past the temporary stage.
Where do you then see the role of the court in being able to put brakes on this transformation? Do you think they failed?
Well, I'm an eternal optimist, and I do believe that the brakes are on the way. Because
You're being somewhat diplomatic in this conversation. In the book, hold on. In the book, you've been much more explicit in calling out the judiciary for, in a sense, emboldening and enabling majoritarianism. You have said the courts are choosing to virtually relinquish their power of judicial review and endorse many decisions of the government.
Yes, I stand by that. I'm not withdrawing that. But the thing is that when you hit rock bottom, there's nowhere else to go except up. Okay, so there is going to be a point of time where the judges are going to say enough is enough, because at the end of the day, what are you doing? You're taking over their power. Okay, and no one likes their power taken away. So whatever be the reason,
So-
we are in for an upward period.
No. So we always live in hope, but we're also in the present moment. And I want your sense, because you've been a observer also and a participant in the judicial system for so long. Why do you think this is taking place? Why do we see the judiciary, the legal system, bend in this manner to power? Is it fear? Is it ideological pressure? A combination? What is it?
See, I don't have the answer to that question. It intrigues me, and I cannot accept it for the reason that they have security of tenure. Our judges have security of tenure. They are indeed more powerful than any politician can ever be. So there is absolutely no logical reason for this. So perhaps the reasons are beyond logic.
Right. And as you maybe you know more than you'd like to reveal in a platform like this, but you do talk about how there is change, or there are sort of these cracks in the edifice. And what we saw recently, where the Supreme Court critiqued its own judgment in the Umar Khalid case, in the UAPA bail matter. That's quite extraordinary, isn't it? To have
It is extraordinary.
something of that nature?
It is extraordinary, but it's a matter of celebration. And so ultimately, perhaps dissent has to come from within the judiciary itself. And you use the right word. It's absolutely extraordinary, but it is also within the grammar of the law, I must tell you. Because what the judges were saying is that there is already a three-bench judgment
Yes.
of the Supreme Court, incidentally authored by the current Chief Justice of India, Justice Surya Kant, which says that if a state is not in a position to give you a fair trial within a decent, reasonable amount of time, which would be a year, 2 years, 3 years,
Yes.
then they have no right to keep you in captivity. They must release you. Now, there is this three-judge bench judgment, and yet we found that benches of 2 judges were not following this judgment, okay? So, the problem is not with us. The problem is that the Supreme Court was not disciplined about its own judgments.
Right.
They're bound by 3-judge judgments, and which is why you saw this observation a few days ago,
Right.
where the judges themselves are pointing out to the fact that we need a discipline of law.
Right. You're saying it's very much within the ambit of the law.
It is.
Well, let me ask you something, Ms. Jaising. You are a very outspoken person. You take on the judiciary. You make critical statements. Hold on. Let me finish the question. You don't. I mean, if I start reading out excerpts from the book.
I'm just doing my job.
Okay,
I'm
you're
not
just doing your
any
job.
of this.
All right, okay. Let me complete the question. My point is that, isn't that something, even as we look at the legal system, at the judiciary, there's always been this fear of being critical of the judiciary through time. Whether it's the question of contempt, whether it's the threat of action, you can be called all sorts of names, you could be called a parasite, whatever it is. Is that something that you have seen getting worse over time, or has that been a constant? And what's the solution to that?
Well, it is getting worse. Let's get that out of the way. No debate about it. But See, there is an observation which Ritu asked me the question. She's here somewhere.
Hmm.
What do you have to say about the right to dissent? I find that question a bit odd. And I told her, it's there. I said, Ritu, where is the question of my dissenting? I told you, I go to court with the constitution in my hand. I'm affirming the constitution in front of you. It is ruling parties who are dissenting from the constitution of India, not us. So let's not call it the right to dissent, okay? They are claiming the right to dissent from the Constitution of India. We are claiming the right to affirm the Constitution of India every time in court.
Well said, but as I said, if the gatekeepers of the constitution, the judiciary itself is straying, and one critiques
When I said they are claiming, I meant all executive
all executive, okay,
governments, okay? What the court does is a different issue. They are supposed to be neutral between us.
of course, but again, as you said, just for doing your job, in your book you outline that comes with reprisals. You talked about how when you were publicly critical of the Justice Gogoi case, when he was accused of sexual harassment, within a matter of days, he opened a case against you under the anti-corruption law.
Yes, under several laws.
Under several
Under
laws.
several laws. It was the CBI. Okay, see, I again do not want to talk about that, because I can only say to you that it was not just for me, for the country as a whole, it was a shame. Okay, no judge can sit in judgment over his own case. And
Yes.
that did happen in this country. And strangely enough, he was one of the judges who held a press conference complaining about how previous judges were manipulating the roster. That's a big issue in India, the way the rosters are set up.
Yes.
Convenience, according to convenience rather than according to the rule of law.
Yes.
But when it comes to me, I was very clear in my mind that I'm not a martyr, I'm not a victim, I'm not a hero, I'm just me. And so when I did face this kind of, what did you call it, an attack
Targeting,
or whatever,
yes.
a backlash, an attack, yes, the biggest challenge for me was how do I continue being a professional, notwithstanding the attack. And so I continued. Of course, the most painful moment was to realize that the institution that I had served all my life was the very institution that attacked me. It was very painful.
I can imagine. Was there ever a point where you were taken aside by quote unquote well-wishers either in the courts, either in the bench or the bar, and said, listen, if you back down, these things go away?
I don't want to answer that question.
Well, maybe you have in a way. I only bring it up because in the context of if someone like you, if an Indira Jaising can face such consequences, then what does it mean for ordinary citizens who want to challenge the judiciary, who want to raise questions? Right? That's a serious concern.
No, again, I
So-
don't agree with your question. I am an ordinary citizen like everyone else.
Well,
And at least I have my freedom. Look at the others, they're behind bars
yeah, that's true.
till today. So I've been relatively.
That's true. Let me ask you then about solutions. What do you think it'll take? I know these are very broad brush and questions that we can spend hours, but briefly, what's the solution? How do we ensure a judiciary which is sort of committed to protecting constitutional values, which will resist executive pressure as much as possible? You can never have a perfect scenario, but which will at least do a better job. How do we get there?
Okay, I think it's a very important question. But in my opinion, it is only a strong bar which can keep a judiciary in check. The tragedy is that we do not have a strong and a militant vociferous bar in this country, okay? And so I can't be expected to carry the whole burden of kind of dealing with the judiciary on my shoulders. I refuse to. I don't wish to be a victim, okay?
Sure.
But I do regret the fact
Yes.
that the organized bar in this country, the Supreme Court bar, often doesn't stand up when they need to stand up. And I do believe that your answer to your question is just that. If a legal profession doesn't stand up to the judges, then no one can. No journalist can, nobody can stand up to them.
Did they do a better job earlier? The Supreme Court Bar Association?
Well,
or have they always been?
No, there have been amazing times in the past when bar associations, various bar associations of various high courts have stood up to oppression. When they have recently, I think Justice Oka said somewhere, when somebody asked him this question, that how come things are going from bad to worse, he did give this answer. He said, what exactly do you expect judges to do? Where is the bar? When we are attacked, we don't see anybody standing up. We don't see the bar standing up for us. So
That's a very important point. I was going to actually ask you, because your book doesn't really address the legal fraternity as such, and you brought that up. But I just want to quickly raise one question about a greater judicial accountability. You talked about the bar, but even in terms of appointment of judges, and you'd mentioned to me earlier that there's going to be an expansion of the Supreme Court after many decades. I believe 4 more judges are being added, and the strength is going from, I believe, 34 to 38, something like that. Is that also critical, that we have more transparency on the appointment? You have the collegium system, of course, which can be considered, whatever one wants to call it, opaque or whatever. But is that also...
It's a big issue. It's a
important,
very major issue, and there's a lot of scholarship around it. Many people have raised the issue that there is no transparency in the way the collegium functions. Of course, we all know, thanks to a young journalist who I think is present here today, Justice Nagaratna's own dissent in the collegium was made public in the Hindustan Times, and that's the kind of transparency we'd like to see. Okay, and it is really the only solution to and I personally feel that the deliberations of the collegium should be actually made public. Okay, so at least we know what considerations go into the appointment of judges or non-appointment of judges. And last but not the least, I had occasion to communicate to the Chief Justice recently in the context of this invitation that now that there are so many vacancies, there are 3 sitting women Chief Justices in India, they should all be coming to the Supreme Court.
I wanted to ask you about that, because I looked at the data and it's quite shocking that in the 75 years of the Supreme Court, you only had 11 women judges. That's only 4%.
Yes.
That's terrible.
Well, of course it's terrible, and even now, as I told you, there's a question mark over whether all 3 women judges, sitting Chief Justices, where could there be any excuse that you don't? And even I've been getting these messages, oh, but where is the merit, where are the women? They're sitting in as Chief Justices of High Courts, and the only question is whether they will be part of the Supreme Court.
It's interesting, though, that in the Sabrimala case, the sole dissenting judge was a woman who actually argued against the temple entry of women.
Feminist scholars here. I think you should ask them that question.
I'm just being just a lighter vein. I just want to ask you very quickly on lawyers, though, because you talked about the bar not rising to the occasion. But can we also take a minute to talk about legal fees, stratospheric legal fees? You've spoken about how you make a compelling case for how marginal communities, etc., should approach the courts, not necessarily the streets. They should seek justice in courts. But how can they afford quality legal representation?
You're right.
I mean, I don't know if they ever could, but it seems to be now off the charts.
No, you're very right. And by the way, we only get to know about fees when we see affidavits being filed in the Rajya Sabha, etc. Otherwise, how would we even know?
So those numbers are true then.
So there's transparency for you, which is most welcome.
Yeah.
But I think what we miss in this country is a really good functioning legal aid system. I think in the audience there is one person who was formerly heading the legal aid services in Delhi, at least, and I know the fantastic work that they did. But the point is, unless you're willing to pay the legal aid lawyers a good amount of fee, this problem will not be resolved. You cannot really expect that people are going to work free of charge. They need to live, they need to survive.
Of course.
And they have to be paid to do good legal services. That's the only way. There's no point in you and me saying we'll do pro bono work.
Yes, of course. No, I agree that it's at the end of the day, these are quote unquote market practices. But was there a time earlier when top lawyers were charging, were the fees as sort of stratospheric, or was it always only
they'll tell you, look at the inflation, then what will the answer will I give you?
Well, I mean, inflation is one thing, 50 lakhs, 1 crore per hearing is another.
Why are you bothered? It's only the Adanis and Ambanis. Let them shed some of their money. It's okay. But
I mean, it's the people who go up against them. I was talking more about them.
the truth is there is no regulation of legal fees in India.
Right. Okay. The other grouse that the ordinary petitioner or the ordinary Indian will have with lawyers, because of course the idea of civil liberties and constitution is important, but it's to do with judicial backlog, the tariq pe tariq culture. And again, aren't lawyers, I mean, all stakeholders are guilty, but aren't lawyers also guilty of this adjournment,
Well, yes.
unchecked adjournment culture?
Yes, they are, and the reason for that is because their daily intake of work is far more than they can handle. Okay, let's be very clear about it. Let's not mince words. And that's where you obviously haven't read what I put wrote my own epigram in the book, where I said, for me, arguing a case is like being pregnant.
I was
for
coming
9
to that. That was my closer. Don't take that this thing away from me. I'm going to ask you that as my
All
closer.
right, then let me just tell you that no lawyer has the right to take on cases beyond what they can actually deliver, beyond what they can handle.
Sure.
It is wrong to ask for an adjournment, just wrong.
Also, from what I understand, that it's also against the law, that the Civil Procedure Code actually says no party should receive more than 3 adjournments during hearings, but it's not enforced. So there's no consequences for seeking tariq pe tariq. So that's again something, I suppose, that you need
there
to
are no
enforce.
consequences, but there is also no reason why judges should
Allow it.
allow it.
Okay.
Very selectively allow it.
Okay, let me wrap now, because I was told we have to stop at 6:30 sharp and it's just gone past. I now want to come to your epigraph, which I found quite intriguing. Let me read it out in full, where you say, preparing a case is like a pregnancy. For 9 months, the idea takes shape and grows in the mind. When it is ready to be delivered, the argument is made in court. That is why I believe only a woman can argue a case well.
Well, I think...
Are you serious, or was this said in jest?
Well, it was part serious, part mischief. Okay. So, but I did want to send a message. Welcome, madam.
Yeah.
I did want to send a message that any day, and here we have the woman who is going to guide us.
Nagaratna,
We
yes.
have,
On cue.
there is no substitute for a woman judge. Thank you.
Okay. Just no, but last thing then. So it was said partly in jest and partly
Yes.
in seriousness. But because not all women lawyers necessarily will be pregnant. Or may
Well,
want to be
neither
pregnant.
have I ever been pregnant.
Okay, fine.
All my cases are my babies. They are my children.
All right. Okay. Well, on that note, we'll wrap it up. Thank you very much indeed, Ms. Jaising, for doing this conversation, and to our audience as well. And of course,
Thank
Justice
you.
Nagaratna,
Thank you.
who's with us.
Thank
Thanks
you.
very much indeed. Thank you.
Thank you. Thank you both for such a stimulating conversation. I would... Yes. As everyone's already witnessed, we are now joined by Justice B.V. Nagaratna, Judge of the Supreme Court of India, whose work and judgments have contributed significantly to contemporary constitutional thought, especially on the questions of rights, institutions, democracy, and equality. Justice Nagaratna is an Indian jurist who has served as a judge of the Supreme Court of India since 2021. She served as a judge of the Karnataka High Court from 2008 to 2021. She's had a wide practice area as an advocate at the Karnataka High Court, where she practiced constitutional law, family law, commercial law, insurance law, service law, administrative law, and many, many others. She has also contributed to the book Courts of India, Past and Present, published by the Supreme Court of India. Further, she chaired the project to translate it into Kannada. Ma'am, we are honored to have you today. Could I please invite you on stage?
Thank you for the introduction. Namaskar and a very good evening to each one of you. Of course, I will refer to Honorable our Chief Justice of India, Justice Surya Kant, who could not be present due to some administrative exigencies. My esteemed brother judges of the Supreme Court who may be watching, there's no sister judge yet. My esteemed brother and sister judges of the High Courts, Miss Indira Jaising, Senior Advocate, whom we say in Kannada, the Kendra Bindu of this function. Mr. Anand Grover, Senior Advocate, learned Senior Advocates and members of the Bar, Miss Ritu Menon and the team which has brought out the book, distinguished invitees, members of the media whom I've seen in large numbers, ladies and gentlemen. I hope I have not left out anybody else. I thank the organizers for inviting me for the launch of the book, The Constitution is My Home. Running through the pages of this book, I find that it is a conversation between Miss Indira Jaising, Senior Advocate, and Miss Ritu Menon, which is quite rare for a book. It is not written out of memory. It is the thoughts which have come as and when the questions were asked to Miss Jaising. But let me begin with the caveat. I must confess that I have not had a chance to read the book from cover to cover. You know the reasons for that. But in any reflective work of this kind, there would naturally be perspectives that different readers engage with differently. Many of you, being lawyers or judges or other readers, may agree or disagree with the views expressed by Ms. Jaising. Similarly, I also reserve my position on those perspectives, interpretations, and propositions. But that is not the reason why I should say that I have come here with some trepidation. I have come here with full happiness when I say that divergent thoughts and perspectives must always be considered and allowed to be expressed. Expression, which we have freedom of expression under Article 19(1)(a), is very, very important these days. That is how it is in a democracy, which we are. In that regard, Ms. Jaising has consistently been at the forefront of articulating alternative viewpoints and perspectives on important issues, particularly those relating to the status and position of women in India and the constitutional rights of the marginalized sections of society. So with that caveat, let me again say that I am happy to be here in this audience amidst all of you to celebrate a senior member of the bar and her professional journey, which deserves full recognition. This book is many things at once: a memoir, a feminist testimony, a constitutional reflection, and a record of a life lived in relentless engagement with justice by enforcement of rights. The title of the book itself is deeply revealing. The Constitution is my home. Now, most lawyers visit the Constitution occasionally and sometimes regularly by arguing Constitution cases before courts, or there is an ambitious argument to bring a constitutional angle to any other case. But Ms. Jaising seems to have taken up permanent residence there. But on a serious note, the use of the word home is very important. The Constitution is my home and not my profession, not my work, not even my calling, but my home. Now, what is a home? A place of belonging, shelter, and source of identity. There is immense power in calling the Constitution one's home. A profession may describe what we do. A calling may describe what inspires us. But a home is where we return to. where we locate ourselves and where our deepest convictions reside. Therefore, the title of the book is very, very significant and unique. To call the Constitution one's home is therefore to declare a deep relationship with its ideals. To speak of Miss Jaising is to speak of us. She was the first woman designated senior advocate by the Bombay High Court, the first woman appointed Additional Solicitor General of India, the first woman lawyer to be awarded the fourth highest civilian award in India, the Padma Shri. She was also one of the earliest lawyers in India to insist that courts must actively touch the lives of ordinary people, workers, women, pavement dwellers, minorities, prisoners, and children, and not only to protect their rights when they themselves approach the courts formally. And that is going to be the thrust of my address. The significance of her career lies not in the list of her achievements, but the consistency of her moral worldview. And I think now it is 8 decades and more and will complete a century. I think there is a thread running through Miss Jaising's life, and perhaps it begins much earlier than her celebrated cases as a lawyer. It begins in her experience of displacement of self-discovery, born into a Sindhi refugee family after partition, moving across cities, and coming of age in Bangalore. My city has something to do with your personality, which, at least for many of us who grew up there, represents a certain openness, a respect for education, and a belief in public institutions. Ma'am, you were in Bishop Cotton Girls' School. I was in Sophia High School. And both the schools had a very healthy competition in co-curricular activities and also in basketball tournaments. Miss Jaising then went to study graduation in Bangalore University. I don't know the name of the college. Mount Carmel? Maharanis, I see. Those days that was really well known. And then to Siddharth Law College in Mumbai. Bombay, it was called those days. Bombay has had a special touch to Miss Jaising. Those years were profoundly liberating. That is also quite unlike Delhi, which I find cultivates social ranks and hierarchies too strictly compared to Bombay, which is more egalitarian. And I think one can see in Miss Jaising's life and career something of that Bombay ethos. Miss Jaising entered the legal profession as a first-generation woman lawyer at a time when the profession was deeply male, deeply formal, and not especially welcoming towards women. Yet from the beginning, she seems to have understood the law as a way of making visible people who had been excluded from power. I'll just run through a few cases which you argued. That thread runs through the major cases in which she was associated with. In McKinnon, Mackenzie and Co. Limited versus Audrey DeCosta, Ms. Jaising appeared for women stenographers who were paid lesser than their male counterparts. It was held that no woman doing equal or similar work as a man employed in the same organization could be paid lesser. She persuaded Justice E.S. Venkatramaya to give the verdict in the favor of the woman, but it is surprising that the case remains, I think, the only decision under the Equal Remuneration Act 1976 in which a woman successfully established pay disparity on the ground only of sex before the Supreme Court. In Mary Roy, she challenged the application of the Travancore Christian Succession Act to Syrian Christian women in Kerala, which effectively gave them only a fraction of the inheritance given to their brothers. The Supreme Court held that the Indian Succession Act would apply instead, transforming property rights for generations of women who had been denied equality within the family. In Olga Tellis, so as all of you know, Miss Jaising represented pavement dwellers in Bombay when they were treated simply as illegal encroachers. Her argument that eviction without rehabilitation destroyed not only shelter but livelihood itself helped the Supreme Court, speaking through Justice Y.V. Chandrachud, to recognize that the right to life under Article 21 included the right to livelihood. In Rupan Deol Bajaj case, Ms. Jaising represented a senior IAS officer who accused one of the country's most powerful police officers then on sexually harassing her. At a time when such behavior was routinely trivialized, she insisted that a woman's dignity could not be dismissed because the accused occupied a high office. The eventual conviction in that case under Section 354 of the Indian Penal Code became one of the earliest legal recognitions of sexual harassment at workplace in India. Similarly, in Geeta Hariharan, Ms. Jaising challenged the assumption that a father was the primary guardian of the children under Section 6 of the Hindu Minority and Guardianship Act. The court ruled that the mother can be a natural guardian even when the father is alive, interpreting the words after him in the said section to mean in his absence. The word absence also was read to include when the father is indifferent, incapable, or not caring for the child, not just physical absence. There is a thread connecting all these cases, and that is, in each case, the people pushed to the margins of the society claimed the full protection of the Constitution. There's another distinction that sets Ms. Jaising apart. She has fought not only for women litigants, but for women lawyers, and not only for giving legal aid, but for access to courts. Even something as seemingly ordinary as a creche in the Supreme Court, it became in her hands a part of the constitutional project of equality. Seeing young women lawyers leave their children under the trees on the lawns of the Supreme Court because there was nowhere to keep them, especially in summer vacation in that heat, Ms. Jaising led the litigation, leading to creche facilities being set up within the court complex. Her constitutional commitment has found institutional form in the work she built with Mr. Anand Grover, whom I must congratulate today for all the achievements of Ms. Jaising. And that shows the Mr. Grover is here, the kind of partnership that they have built, and their other colleagues through the Lawyers Collective, which was also a bulletin. I remember my father used to ask me to read the Lawyers Collective. It used to come by post, and I remember reading that in the 80s. Together, they helped create one of the most important public interest legal organizations in this country. That impulse continues in the leaflet, the legal news and commentary platform she co-founded with Mr. Grover in 2018 with the wonderful motto, Constitution First. In some ways, that phrase captures the arc of her life, an insistence that the Constitution is not the domain of lawyers and judges alone, but a democratic ethic that must permeate public life and private life of every citizen. So through Ms. Jaising, the women only ask that the barriers of prejudice, exclusion, and paternalism be removed so that merit, scholarship, and courage could speak for themselves. What makes the journey of any woman in law truly extraordinary is not merely her professional success, but also the quiet reshaping of institutions that her mere presence leads to. That is the kind of personality she has built. Let me say how the generations of women have, I must say, thrived in the profession. The first generation of women in law had to prove they deserved to enter the portals of the law courts. We know what happened earlier. The next had to prove they deserved to be heard. The next generation had to prove that they could be senior advocates. Then they had to prove that they could argue the most important constitutional and commercial cases. So with each successive generation, the burden becomes a little less onerous. From fighting for entry to demanding recognition to reclaiming leadership. But as women, we ought to keep in mind that each generation carries forward not only its own ambition, but also the accumulated courage of the women who came before them. What once required exceptional defiance slowly became routine, which has acquired acceptance and recognition. And that is how institutions change. Not suddenly, but slowly through the steady persistence of those who refuse to remain at the margins and their persuasions with the powers that be. The legal profession can be intensely competitive, but the most enduring progress has come when women refused isolation and chose solidarity over scarcity. For generations, men in the legal profession have benefited from social networks of familiarity, recommendation, and professional sponsorship. There is, in fact, almost a kind of a brotherhood, an exclusive male club, which lies in this inherited ease of belonging, the confidence of moving through systems where they almost naturally fit in. But for women, by contrast, they have entered the profession without such network and ease in most cases. That is why sisterhood in the profession is very important. Sisterhood in the profession is not a slogan, but as a conscious intellectual and professional commitment to ensuring that access does not end with individual achievement. Senior women lawyers have achieved a lot, but what are they doing for the junior women lawyers? I would say for the junior lawyers, maybe a woman or a man, I won't restrict it. The commitment of senior advocates to mentor junior advocates is very important. I find that the juniors, when they enter, for example, the bar, it is with a high degree of hope and ambition. But after a few months, there is some kind of a negativity, a depression. Therefore, the mentorship from seniors and even not so seniors but experienced lawyers in the bar for these junior members is absolutely necessary. Women are equal claimants to this nation's intellectual and institutional legacy. As we continue discussions about inclusion, equality and justice, let us also choose our words carefully. Women are not newcomers. They have always been there. When Adam was there, Eve also was there. They are not newcomers to this planet. They are citizens, equally, contributors, thinkers, and leaders in their own right. Today, we should remember Justice Anna Chandy, the first woman judge in India. Cornelia Sorabji, the first woman to practice law in India. Justice Fatima Bibi, the first woman judge of the Supreme Court of India. And no less, the legendary freedom fighter and member of the Constituent Assembly, Rajkumari Amrit Kaur, who in 1932 in Jalandhar said, and I quote, "The women of India are no longer willing to submit to standards, whether local, political or ethical, which have been set for them by the male conscience of the community. We are passionately aware that such standards have often been allowed to imply the complete subordination or even degradation of whole classes of women. We are aware of the necessity of finding and being judged by our own standards of free human beings, voluntarily accepted. We are determined to face the facts of life, to fight the battles of our sex, and to take the risks." Unquote. This solitary statement is a soaring reflection of the socio-political churn that ultimately crystallized into the Constitution. We all know that we had 15 women in the Constituent Assembly. And we should say now the parents rather than saying the fathers or mothers. Let us say parents, mothers of the Constitution. It is in this spirit that Miss Jaising has taken forward through her work, spanning for about 6 decades, which is a unique achievement indeed. To return to the book, I would be remiss if I didn't mention a few things about the format of this book, which is to my mind something unique and it stands out. Miss Ritu Menon, with a lot of sensitivity, has chosen oral conversation as a vehicle for her narrative. I find that choice very interesting. The book tries not to chronologically sequence the life of Miss Jaising as much as to capture her voice through a series of conversations on different themes. Therefore, the book does not read like a distant legal archive. It feels intimate, immediate, and alive, and that is because of the format of the book. The conversational format restores something often missing from legal history: voice. Law reports tell us judgments, but they don't tell us the strategy, loneliness, fear, or hope of litigants and lawyers within the courtroom. This book does. We almost hear memory, recollection, doubt, anger, and conviction. The nuances of speech, pauses, and emphasis, which are often lost in the written word, are captured in this book. After going through the book, something struck me, and I wish to specifically mention that. I want to refer about the particular kind of public interest or constitutional lawyering that Ms. Jaising has been spearheading, because its contribution is often understood too narrowly. Usually, people acknowledge that it touches real lives, protects livelihoods, affirms rights, defends vulnerable individuals and communities. I believe lawyering of this kind deepens democracy by bringing marginalized people into the mainstream of constitutional and civic life, rather than leaving them at the mercy of extra-legal systems, and instead it contributes to nation building. I wish to end by saying that young lawyers will read this book and discover what fearless advocacy looks like. If next time you want to know what is fearless advocacy, we should say it is synonymous with Ms. Jaising's advocacy. Whether it is before a single judge, a division bench, a 3-judge bench, a 5-judge constitution bench, or for that matter, a 9-judge bench. And if the law is to grow, it could even be a 11-judge bench. Women will read it and recognize the long struggle behind the rights. And citizens at large should read it and understand that constitutions are not self-executing, but have to be worked upon by individuals almost every day. Very few people alter the vocabulary of public life, and Ms. Jaising has done that to a great extent. After her interventions, terms like workplace equality, sexual harassment, domestic violence, women's inheritance, and power imbalance, there may be many more, have entered the mainstream of Indian jurisprudence. That by itself is an extraordinary legacy, madam. I must also mention one curious fact. That is, when Ms. Jaising appears before us in the Supreme Court, we, the judges of the Supreme Court, are at least 20 years younger to her. We find ourselves being assisted by someone who is not only older in age, but older than the Constitution. We are being called upon to interpret. It is indeed extraordinary that she has a long relationship with legal rights in India. I hope that the gap between Ms. Indira Jaising and the Supreme Court widens, so that in the sense of age, so that even if she crosses a century, she is still, as a centenarian, arguing before the Supreme Court. So today we are honoring a lifetime of faith in the Constitution and its values. I wish Ms. Jaising all the very best in her future endeavors, and she may achieve, or whether she has already achieved, the platinum jubilee of her success as an advocate and crusader for the enforcement of the Constitution and legal rights to the people of India. My best wishes to you, madam, for good health and happiness. I thank the organizers of this event for having invited me to this unique event. I thank each one of you for your patience. Thank you and namaskar. In honor of Ms. Jaising, let us all stand up and give a standing ovation. I extend my congratulations to Ms. Jaising and to the Ms. Ritu Menon. Yes, congratulations for bringing up, and her team for bringing out this very unique book, which is in a conversational form, and which, when you hear a conversation, it is more, you see, has a greater impact than when you read something. Thank you again. Namaskar.
Hi, ma'am.
People are leaving, huh? But you have to.
Hi, there's still more. Please do wait. Could I please invite Justice B.V. Nagaratna, Indira ma'am, and Sreenivasan Jain, and Ritu, please, on stage to launch the book.
Srinivas. Only books are there. Oh, we have to still do this.
There's also a feature clip. There's a bit more. But yours, Justice Nagaratna. Yes, yes, but think.
My father was here, expected from my.
Will you hold this one? She picked up it.
Come this side.
It was amazing. Yes. Yes.
Hi, could I please request everyone to... Hi everyone, please, just a minute. Could I please request all of you to hold up the book? Yes, could I please request all of you to unwrap the book now?
hold it too high, my face.
Thank you. Now we do have a video clip from the Chief Justice of India, who couldn't, of course, be here, but he has sent a speech and a clip to address everyone here today.
I extend my warm greetings and best wishes on the occasion of I extend my I extend my warm greetings and best wishes on the occasion of the launch of Ms. Indira Jaising's memoir, The Constitution is My Home, Conversations on a Life in Law. I mu- I extend my warm greetings and best wishes on the occasion of the launch of Ms. Indira Jaising's memoir, The Constitution is My Home, Conversations on a Life in Law. I must begin by expressing sincere regret at being unable to join you this evening, owing to an urgent meeting related to preparations for a prestigious upcoming international conference of judges of BRICS countries hosted by the Indian Judiciary. I am unable to be present on this special occasion. Knowing the significance of today's event, I felt it important to convey my heartfelt wishes to Ms. Jaising and to the organizers. Occasions such as these are moments to reflect on long journeys in the law and on the lives spent engaging with questions that shape our legal and constitutional discourse, much like Ms. Jaising has done over the past 6 decades. I therefore did not wish to allow this occasion to pass without conveying a few thoughts of my own. Though I am unable to be present personally, I had prepared some reflections for this gathering and would be grateful if they could be shared on my behalf. I request the organizers to kindly read out the address I had intended to deliver on this special occasion. Thank you very much. I extend my warm greetings and best wishes on
Okay, we have a short speech from the CGI. I plan to not spend too much time, but just to read a short excerpt from it. Rarely do we think of a constitution as a home, and yet only a few metaphors could possibly capture Ms. Jaising's legal journey with such depth and accuracy. If one reflects upon that metaphor a little more closely, one begins to appreciate why it carries such enduring resonance. A home is far more than a physical structure. It is a place of belonging. It is something I believe we inherit from those who came before us, inhabit during our own lives, and eventually leave for those who follow. Every generation alters it in visible and invisible ways. Rooms are added, foundations are strengthened, and changing needs require thoughtful adaptation. Yet, amidst all these changes, the identity of home continues to endure. In many ways, our country's constitutional journey has mirrored that process. We too have inherited a framework which was made with extraordinary foresight by the framers, within which we reside as citizens, constitutional functionaries, institutions, state, and public actors. Over time, we have reinterpreted its principles, expanded the meaning of its guarantees, and responded to the changing needs of society. But through all these developments, the Constitution continues to draw coherence from the values on which it was founded. The Constitution is not simply a legal text governing society from a distance. It is a shared framework within which shared aspirations are articulated, negotiated, and realized. For those of us who spend our lives in the pursuit of the law, we know that the Constitution is a constant presence. It accompanies us in courtrooms and chambers, in arguments and deliberations. But its reach extends far beyond formal legal spaces, and its influence is ultimately measured in the lives of citizens and in the character of our democracy. I believe that through this continuing dialogue, legal interpretation acquires not only authority, but democratic legitimacy. Ladies and gentlemen, every generation encounters questions that earlier generations could scarcely have anticipated. New technologies, shifting social realities, and evolving understanding of rights continually test inherited assumptions. The strength of our legal framework lies in resisting these questions, not in resisting these questions, but in possessing the capacity to engage with them. And perhaps this takes us back to the central metaphor of the evening. A home survives not because its walls remain untouched. It survives because each generation cares enough to preserve what is essential while adapting what is necessary. Thank you. Okay, so now to conclude the evening, we're so grateful to Indira ma'am for trusting us with this book, to Ritu Menon for bringing to these conversations depth, care, and intellectual generosity. The result is a book that is essential reading not only for lawyers and students of law, but to anyone concerned about the promises that still animate our democracy. Our grateful thanks to all our speakers, the CJI, Justice Nagaratna, and Sreenivasan Jain for the most stimulating conversation I've been present for in recent times. And to all of you for being such an engaged audience. Thank you so much. Just to add, the books are available outside in case you have not got one. Please do. Indira ma'am is around. Please queue up in case you want to get your copy signed. We'll make sure that it's done duly. Yes.
Yes.